Maria Carla Chiquin. I have the honor to serve as Founding Executive Director of Casa Cuba, a new initiative at FIU to create a hub, a leading global venue for the study, for the creation and dissemination of knowledge of Cuba and the celebration of Cuban culture. As some of you know, I'm sure, in 2015, the university announced plans to build Casa Cuba as a venue for significant academic assets and collections related to Cuba. Since then, Casa Cuba has launched operations and programming, secured a prominent location at the Modesto Manrique campus to build our state-of-the-art facility, engaged a distinguished board of advisors composed of prominent leaders, predominantly from the Cuban American community, and raised significant funding from individual supporters and renowned organizations like Knight Foundation and National Endowment for the Humanities. So today, I am very proud to say that Casa Cuba is well on its way to fulfill its vision as an international think tank that gathers academics, business leaders, and policymakers for the rigorous study of Cuba. And today's event is an example of that, of our commitment to become a forum for the most consequential conversations on issues in all disciplines affecting the island nation. I would like to thank the FIU Cuban Research Institute for organizing this event, and Reinvigorated Helms-Burton, Coming Storm, or Sunshower, under the leadership of its director, Dr. Jorge Duani. I would like to thank our co-sponsors, Holding and Knight, Jones Day, Shelton Bowen, Cuban Banking Study Group, and Florida International Bankers Association. And I would like to thank our panelists, Dr. Michael Bustamante, Dr. Manuel Lazaga, FIU professors, as well as Rick Puente and Amy Valdivia, who will be introduced by our moderator, Camila Fernandez, at today's panel. And now I would like to invite my colleague, Dr. Jorge Duani, to the podium, and thank you all so much for being here today. Hope you all enjoyed the discussion.
Thank you, Maria Carla. Thank you all for being here. Good morning. We're delighted to have you here. I think it's one of the few events we're having at this venue, the FIU Brickell downtown campus. So it's a great pleasure to see all these lawyers and bankers and other interested persons in the topic. So I just want to say a couple of words about what we do at the Cuban Research Institute, which is, among other things, organize events like this, public events on Cuban and Cuban American topics. We do approximately 50 to 70 events every year. If you haven't found out, you can look at our website up there, cri.fiu.edu, and you can come to many events. It so happens that this semester we've had several events dealing with legal issues, including the discussion of the Constitution and this event, and we hope we can engage the legal community in other events. CRI, or Cuban Research Institute, was founded way back in 1991. We'd like to say that we're the foremost institute devoted to Cuban and Cuban American studies. By foremost, we mean the oldest, but also I think we're at least among the top research institutes. We have the largest number of Cuban and Cuban American scholars and faculty members, more than 50 on our staff. We also are proud to have the largest number of Cuban American students. We don't know exactly how many, but we think it's about a third of our student body. And we can organize the largest, and of course we have to exaggerate some of these Cuban things, the largest Cuban and Cuban American conference with more than 280 scholars and students and people from around the United States. And sometimes we're lucky to have some people from Cuba this year because of the visa situation that we're limited. Another major event that we organize every year is the Cuban concert. Concert. You can look forward to that in December, first week of December. And then on a more regular basis, we organize book presentations. We actually just presented Michael Bustamante's excellent book on Cuban history. Most of these events are held at Books and Books because people like to come to Bogota. We do film screenings, we do lectures, anything that we can do to encourage original research and teaching on Cuban and Cuban American studies, we do that. So welcome again, and now I want to ask Fernando Casablanca to come up to talk to me. Thank you.
Thank you, thank you all. My role here today is very simple. Just to welcome you again on behalf of the Cuban Bachelor Study Group and FIU Casa Cuba. This is our first joint event together, and I hope we'll be one of many. I hope to do many more. I'm not going to talk about, don't worry, I'm not going to talk about banking today. I will say one thing, Cuban Banking Study Group was founded in 1992, almost as old as CRI. We're probably the only, our mission is just basically to study the Cuban banking and financial system from its very inception in 1832, first bank created in Cuba, until today. We've done a lot of research into the subject. We even held probably the only international banking conference held in Havana a couple of years ago, with representatives from all the agencies in Washington, among other things. But it was not done under the it was done with the blessing of everybody in Washington. Our organization, our group, I want to say this because it's appropriate to the theme today. The Cuban Cuban Banking Study Group, working with the Cuban Bankers Association, which is the association of the former bank owners, is probably the only industry, to my knowledge, that has an agreement on how to deal with the nationalization of the privately owned banks in Cuba, those that were nationalized or expropriated in 1961. It's the only one that I know that has dealt with that issue, and very satisfactory. So anyhow, with that as a background, I turn the program over to
Camila.
Camila. Up to you. Thank you all for coming. Appreciate it.
Thank you, Fernando. So, hi, my name is Camila Fernandez. I'm with the law firm of Helms-Burton. I'll be moderating today's panel on Helms-Burton, as you know. So first, we're going to have Rick Puente, who has not arrived, but he is on the way. He's one of our panelists. He was just held up. He is with the law firm of Jones Day, and he's in the Global Disputes Group. Then we have Aime Valdivia right here next to me. She's with Holland and Knight, and she has experience with the Cuban Assets Control Regulations, and she deals with international transactions in her practice. We also have Dr. Lasaga, who is a professor at FIU, and he will also be discussing the topic with us today, as well as Dr. Bustamante, who is also a professor at FIU. So I will get started. I think, just so you know, the panel, I will have some questions for the panelists. Then next, I will allow the panelists to share anything else that they have with you, and we'll proceed at the end with a Q&A so that we can take your questions and the panelists can answer them for you. So I think the first question I have is if we could start with a bit of historical background about how Helms-Burton came about. Maybe we can talk about the events which gave rise to the law, or presumably gave rise to the law. Just a bit of historical background. Perhaps one of the professors could take this one. Yeah.
Go first. Oh, you're going. Should have done it not. Well, it's a pleasure to be here this morning. So I'm a little bit like the odd person out of the panel. I'm not a lawyer or a banker. I'm a historian. So I think this question does fall in my wheelhouse. This is a question that could have a very long answer. I will try not to do that. But I would say that to understand the origins of Helms-Burton, it's important to understand the broader context in which it emerges, and not just even in, say, the year or two preceding it. I really think it's important to situate a law like Helms-Burton in, first, the broad context of the end of the Cold War, and the focus on Cuba in that juncture as the kind of presumably next domino that will fall. There is a sort of heightened sense of expectation, probably beginning in 1989, and certainly through the early years of the 1990s, as Cuba enters into really an unprecedented economic crisis, that the Cuban state as such cannot outlast the crisis. Joined with that, I think it's also important to keep in mind that this is also the era of really the rise of Cuban American politics. Certainly Cuban Americans had begun to have a more prominent place in politics at the local level and in the state of Florida in the 1980s, but the election of Ileana Ros-Lehtinen in 1989 to the Congress, I think, really signals the sort of rise of Cuban American politics at the national level in a way that wasn't quite the case before. And so that leads to a new degree of influence for sectors of the Cuban American community that see this moment in the early 1990s as a moment to strike, if I'm being frank. There's a general move toward U.S. policy tightening in the early 1990s thinking being that this is going to help push Cuba to be the next domino to fall from the socialist world. And so before anything like Helms-Burton is even sort of on the map, there's a number of other pieces of legislation and policy action that I think precede it and that are important. We could talk about everything from the creation of TP-Marti in the early 1990s, which was created to complement Marti, which had been created in the 80s. We could talk about the involvement of not just U.S. policymakers in the George Herbert Walker Bush administration, but also policy advocates from the Cuban American National Foundation, who were in dialogue with representatives of the Russian government, including with the Gorbachev government, to encourage them to cut off their subsidies to Cuba at this time. We could talk about the Cuban Democracy Act, also known as the Torricelli Bill of 1992, which, among other things, attempts to cut off the trade between Cuba and subsidiaries of U.S. corporations, which had been re-allowed in the 70s. And I think certainly also an important part of the backdrop is the 1994 rafter and migration crisis, which led to a series of migration reports that those who were in favor of some of the other policy actions that I just described felt were something of a concession or even a betrayal, insofar as the wet-foot dry-foot policy presumed that the U.S. government for the first time would actually proactively return Cuban migrants who did not make it to U.S. shores. So Helms-Burton itself is passed in early '96, but it really has its origins right after the midterm elections in 1994. It's worth noting that the Clinton administration really campaigned on tightening Cuba policy, sort of opposed to how we think of the kind of party alignments on these issues today. The Cuba Democracy Act of 1992 had been a campaign issue in the 1992 presidential election. But the 94 midterm elections, as many will remember, swept in a kind of conservative revolution, and that created a new opportunity for the advocates of increased policy tightening to push forward further legislative action. And so really from, shortly after the midterm elections of 1994, which really come on the heels of the rafter crisis, it's worth thinking about that coincidence. Legislators Dan Burton in the House and Senator Jesse Helms in the Senate begin working on kind of complementary versions of the law that would eventually become known as the Helms-Burton legislation. I think from a historical perspective, it's worth thinking about sort of who these legislators were and some of the, to put it mildly, complicated legacies that they brought to the fore. Jesse Helms being well known not only as a kind of staunch anti-communist, but also a former Dixiecrat and pro-segregationist in his early political career. And the Helms-Burton legislation was really a response to the sense that despite U.S. policy tightening in the early 1990s, despite the scale of Cuba's economic crisis, that the proverbial domino had not fallen, and that international investors seemed to be helping to quote-unquote bail out the Cuban government. And so the Helms-Burton legislation is crafted in part with this idea of how to sort of attack or target these third country investors who are getting involved in Cuba's economy, including with properties that are the subject of litigation and claims dating back to the late 1960s. I think one thing to note about the Helms-Burton legislation is that this was not a piece of legislation that was guaranteed to be successful. It met a lot of opposition, not only in the Clinton administration or the Democratic Party, but also among some moderate Republicans at the time. Title III, which I gather is one of the main subjects that brings us here today, was a huge source of controversy then, as it remains now, insofar as it kind of opened the door to lawsuits against, say, European or Canadian companies. There were all kinds of issues of extraterritoriality that were raised about this. There was a real geopolitical concern about the way in which should this kind of provision be implemented, the kinds of problems that could create for U.S. relationships with very important allies in Europe and elsewhere. And so it's not, it wasn't a foregone conclusion that this law was going to be for it to be passed. In fact, to get it passed out of the Senate, Title III had to be removed. Title III was removed, Title III being the provision that allows these lawsuits that, again, I think are the source of many of our interests here today. This was removed. And Jesse Helms said, well, we'll sort of go on to fight a better day, a better battle in conference committee. But then, of course, or just to say quickly, I think some suspected that whatever version of the law might be passed might have been headed toward a veto. But then in February 1996, the shoot-down of the brothers to the arrest claims took place. And that created the context in which the Clinton administration really drops its opposition or its hesitancy and sort of moves to get the law done. Title III is reinserted to the law, but with the important new addition of a presidential waiver. That is, the Clinton administration insists that if we're going to do this, we have to insert an ability of the executive branch to waive the implementation of Title III. And as I'm sure we'll talk about, Title III has effectively been waived ever since until very recently. Just other things that I think that the Helms-Burton law did that are important just to put on the table that I'm sure many of us know. In addition to allowing lawsuits for pertaining to those trafficking in confiscated property, it conditioned the lifting of the embargo on a series of very detailed circumstances that would have to take place in Cuba before the embargo could be lifted. It did not create a sort of more step-by-step incentive structure, one might say. Importantly, too, with respect to the lawsuits, it broadened the definition of U.S. nationals that would be eligible to bring these kinds of suits to court to not just U.S. nationals who were nationals at the time of property confiscation, but also people that had become U.S. nationals subsequently, i.e. People who had been Cuban citizens at the time. And so their claims have not been certified in the previous claim certification process, and this also was a real source and remains a real source of controversy and dispute. And finally, the Helms-Burton legislation codified the embargo in a way that it had never been before. After Helms-Burton, the executive branch is much more curtailed in its ability to simply strike down the embargo whole hog, although there's been a lot of debate about the degree of executive authority that the White House maintains. So it really marked a watershed, and I think kind of the most aggressive of the sort of pro-sanctions legislation that had come about progressively in the early 1990s. And so I hope that's a bit of context to help situate the conversation.
Thank you. Yes, very helpful. Do you have any other thoughts on the history that you would like to share?
Well, I just add to what Michael Bustamante said. This is basically implementing a clause that probably generated the most opposition at the time of the legislation because of global concerns about third countries that invest in Cuba. The question here is going to be how is this going to be implemented? And in that regard, then it will achieve the goal of preventing investors who are considering but not really committed to investing in Cuba to stand by and see how this develops. So it will have an impact if it is basically allowed to take its course. So I think that that's something that probably more so, not so much the individuals who will be filing suits. I mean, and the question is who's going to write the check at the end of the day, and then of course the strong opposition overseas. I think that that's something that will the U.S. will have to contend in terms of consequences.
And I think just adding to what Dr. Lasaga mentioned and what Dr. Bustamante pointed out, the statute itself is focusing on extraterritorial conduct, right? So Congress here has taken up the task of legislating within the statute and prohibiting and prescribing conduct that is occurring outside U.S. soil. And it'll be interesting to see how the courts address this issue, right? Because now because of Title III, you're now involving the courts, the judicial branch, in what some would argue is foreign policy, right? Because it's extraterritorial conduct. And again, there's been no cases on Title III, right? Because it's been suspended, so I'm not going to be speculating on what the courts are going to do. But it's interesting to look at some opinions where the Supreme Court has looked at extraterritorial conduct and determined whether a statute, for instance, is valid or not, and whether or not the conduct being prescribed is valid or not. And you know, one case that comes to mind is Morrison versus National Bank of Australia, where it didn't deal with Helms-Burton, and not to get esoteric on legal topics, but it could be analogous, where Justice Scalia wrote the majority of the opinion saying that the text of the statute, which involved the anti-fraud provision of the Securities Act, and involving claims under the anti-fraud provisions, whether it applied to conduct in Australia. And Justice Scalia, in the majority opinion, concurred was, you look at the statute, is the statute legislating conduct outside the U.S.? And here the anti-fraud provisions of the SEC Act were not legislating conduct. So that in itself was enough to say that's not going to hold up. Here Helms-Burton is actually legislating conduct outside the U.S., right? And so you have to now look at other statutes that may be focusing on that. And one that comes to mind is the RICO Act, and specifically RGR versus Nabisco, RGR-Nabisco case versus European Union. The European Union there filed a lawsuit seeking compensation. Now, they were foreign plaintiffs. That's the distinction. It was foreign plaintiffs seeking compensation for anti-money laundering activities alleged against RGR. And there, the court seemed to restrict, because ultimately the case was dismissed, seemed to restrict the application of the extraterritorial act of RICO because of the conduct. The conduct wasn't sufficiently tied to the U.S. So, you know, how the courts are going to address this issue will be interesting, because here you do have U.S. nationals under the Foreign Claims Service Commission. They are the plaintiffs. Under the certified claims, also you have the bucket of non-Foreign Claims Service Commission plaintiffs. And then they are going to be, there's going to be issues of standing, and there's going to be issues on whether this extraterritorial effect, this extraterritorial conduct itself is sufficient to provide standing and to uphold the jurisdiction of the courts. So it'll be interesting to see how that manifests itself. And also, of course, you're going to have personal jurisdiction issues as well. There's a case that in the U.S. Supreme Court involving Daimler, the Daimler case, and I can give you the site later, which basically says if you have a subsidiary in the U.S., that's not going to be enough context to satisfy the minimum due process concerns. So courts are going to be, and ultimately these lawsuits are going to have those defenses, the personal jurisdiction defense, the standing defense, the extraterritorial effects of the statute. All that is going to come into play. So it's not as easy as people seem to perceive. In addition, you're going to have the European locking statutes and statutes that penalize conduct involving Helms-Burton. They're meant to go against. They're basically anti-blocking statutes. They're called. They go against the idea that U.S. plaintiffs can seek compensation against foreign companies for acts that are occurring outside the U.S. And the European Union is saying through some of its laws and its regulations that is violating public policy, that's not going to be enforceable in those countries. So as Dr. Lasaga said, you get a judgment, then you have to execute on assets, right, on that judgment. And that's going to be a complicated scenario as well, because then you have to look at, where the assets are located. If the assets are in the U.S., well, that's going to be simpler, right? If the assets are in Europe, that's going to be much more complicated, or in Mexico, or in another country.
So I think we can take a small step back just to give a bit of an overview of Title III and talk about maybe what it does and why it has become. We've talked about the ability to waive it or suspend it. So maybe just take a step back and tell us what it does, why is the subject of recent discussion, and why it matters. Maybe I need you.
Yeah, sure. Well, Title III is one of the four titles of the Helms-Burton, the Cuba Liberty Act, and it basically says that any person that traffics in confiscated property in Cuba is liable, for that traffic towards the person that has right or a claim on that property. And I think that is helpful to, although many of us are familiar with the law, to try to analyze each of the components of this whole Title III. For example, traffic, the definition of traffic is very broad, and in addition to include selling, transferring, buying confiscated property, it also includes the use of confiscated property for commercial purposes directly, and even benefiting from the use of another person of that confiscated property. It has some exceptions, the definition of traffic. One of them is the use of confiscated property for personal use by Cuban citizens. For example, if someone was, bought a house or was assigned a house by a government and that house is confiscated property, and that person is not, an officer of the Cuban government or the Cuban Communist Party, and is living in that house with their family, that use of that house is not trafficking. So that person would not be liable on the Title III. The other exception that is very interesting is the travel exception. It says that if the use of confiscated property is incident to lawful travel and is necessary to complete that lawful travel, then that is not trafficking. So the question here, of course, would be a discussion, what is necessary to lawful travel? We know that under the OFAC regulation, there are 12 categories of authorized travel under which U.S. person can go to Cuba. And, an argument is, okay, so I need to use the airport, I need to use the port to go to Cuba, because otherwise I cannot do my authorized travel. To what extent that is, an absolute argument, or there could be, another one that you can still go to Cuba and enter Cuba by one of the airports or that are not confiscated. You not necessarily have to use that one. So that would be a debate, but that is one of the exceptions, and or would be one of the defenses. For travelers, individual travelers, I think that they are covered. There will be for, carriers, airlines, and cruise lines that use, in connection with local travel, in connection with carrying people to Cuba that use those confiscated properties, that would be an interesting debate. So confiscated property is any property that was confiscated, nationalized in Cuba after January 1st, 1959. And the potential plaintiff could be any person that is a U.S. citizen at the time of the claim, but that acquire title on the confiscated property or title to the claim after, before 1996, that is the date of the Helms-Burton. I think that would be for plaintiff. Also, there are some exceptions for the plaintiff. For example, if that claim could be brought, that plaintiff was eligible to bring the claim under the International Cuban Claim Commission, and that plaintiff didn't take advantage of that, then now they cannot claim under the Title III. Also, if the claim under the Cuban Claim Commission was denied, then that plaintiff cannot, bring a claim now on the Title III. And defendants could be any person, any company, individual that is, again, trafficking in confiscated property. I think that in 1996, when the law was, Title III was enacted, nobody was thinking that, potential plaintiff, defendants could be U.S. Companies or individuals, but now that is a possibility in the event that Title III is no longer suspended. Now, has been under authority that the act gives to the President of the United States, suspended every 6 months since 1996, and for the first time in January this year, President Trump suspended Title III for only 45 days, and then in March, at the beginning of March, suspended it again for 30 days with one exception. So starting March 19, there is a limited kind of claim that can be brought on the Title III, and those are only against a limited list of Cuban entities, which we call the restricted list, which is a list that is issued and published by the U.S. Department of State. And these are entities and sub-entities, for example, hotels, that are under the control of the Cuban military, of the intelligence forces in Cuba. And is a restricted list, is specifically, so the defendants could only, for now, unless, you know, is some different application of Title III is announced, which, by the way, should be announced today because the next deadline is April 17. So there is a 15 days notice requirement to Congress. So it should be announced today what would happen starting April 19, whether there would be the same limited application, there would be suspended again, or if they would allow a more broad application of Title III.
Maybe we can talk a little bit about briefly about the suspension history. What kind of, why the presidents have perhaps suspended Title III for so long? Have they received pressure from certain countries, which I think is the case? Maybe Rick, you can start.
Sure.
with that.
Well, if you look at the legislative history, and as Dr. Bustamante alluded to earlier, the Title III was really a concern from day one, right? When this law is introduced, again, because it's providing a causes of action for conduct that's occurring outside the U.S. So that in itself brought the concern. What ultimately, I think, led to the passing of the law, and to the extent I repeat myself, I think it's just necessary to emphasize what was going on historically, right? And that's so important because, again, Cuba's losing the subsidy of the Soviet Union, $5 to $6 billion per year that they were being subsidized. They're trying then to make up for that necessity to get cash by creating legislation, amending the U.S. Constitution to permit foreign investments in 1992, I believe that was. And then later, they passed an investment law in 1995, specifically allowing investment in Cuba in partnership with the Cuban government, joint ventures, et cetera, right? So then that brought in, right, we have these under the International Claims Settlement Act of 1949, we have the certified claims by the Foreign Claims Service Commission of all these properties expropriated from U.S. nationals, just U.S. nationals, not Cubans, right? And back then it was close to $2 billion. In today's dollars, it's worth $8 billion. That now mounts into pressure with what's going on in 1996, right? When you have the Brothers to the Rescue planes being shot down, right? And then I remember Clinton alluded to a transcript that was obtained where supposedly the MiG fighters were joking about it was interpreted as joking about the shoot down, right? And there was a debate as to whether or not it occurred in international waters. So now, wait a second, you have this investment law in Cuba in 1995, and you have Spanish companies in particular investing heavily in Cuba, and you have these events transpiring, right? So the pressure is on, I think, on President Clinton to sign the law, right? And the law, the way it was passed in March, I believe, of '96, specifically allowed the president to suspend for 6 months, right? So what Clinton says in July of '96, there's some documents that you can obtain from the White House, which shows that he was saying, I'm going to allow, he says specifically, I'm going to allow the law to go into effect, but I'm going to put basically the world on notice that you know, it's going into effect, I'm gonna suspend it, but it's in effect. So the world is on notice that if you traffic on properties belonging to US nationals, you're going to be potentially liable in US courts, right? So that's how the law is passed, but ultimately it's suspended, right? Because the European community and Mexico had invested already in Cuba. They found this to be legislation that impacts their own sovereignty and the rights of their companies to engage in investments in Cuba, what they deemed lawful investment in Cuba. So there were these pressures, and then every president, including through Trump, has suspended the Title III. Bush suspended it, Obama suspended it, every 6 months they suspended, until obviously we have this change, this shift, where now it's being suspended initially for 45 days. Last time it was suspended for only 30 days. You know, I mean, the panorama itself is complicated, and how the courts are going to view this is complicated because, again, there are now OFAC licenses permitting activities in Cuba, right? And so how is that going to affect? If companies are saying, well, U.S. companies that could be sued, let's say, because they're trafficking, let's say somebody mentioned the port earlier, right? If they're using the port, they're going to say, well, we have an OFAC license that permits this, or the travel is incidental, it's necessary under Title III, and that'll be a debate. Doesn't that OFAC license shield me from liability under Helms-Burton? That'll be an interesting debate, and how the courts are going to address that issue. There's no case that we can look at right now under Title III Helms-Burton dealing with this, right? But it's Congress legislates. OFAC is under the executive branch, so there's you know, what's great about our Constitution here in the U.S. is that we have this balance of power, right? We have the Congress, the law, we have the executive executing. Is a regulation going to trump a law? You know, you have to look at other precedents involving maybe similar types of statutes to see how courts have addressed this issue. So it'll be interesting to see how this manifests itself. But the pressure has always been there from day one for Congress and the president in signing ultimately this law into effect, and that's why the suspension has taken effect. Now we've seen Trump to be a president that is not too concerned about the world opinion, right? Or at least that's what he portrays himself as. So may he be the first one that just doesn't suspend it? I think we'll know. We'll know very soon, maybe by the end of today, right? Because it's 15 days notice, as Amy pointed out, that we'll know, right? So a lot of people will be on pins and needles.
I think also that in terms of timing, right now Cuba is at the bottom because it just lost the biggest supporter of the Cuban economy, which is Venezuela. There's not many left. Russia doesn't have that much economic leverage in the global scene today, unless oil prices go up to $100 a barrel in the near future, which is not likely. So if there is a time that intensifying the embargo tools, this would be the time to do it where it would have an impact on Cuba, because if they lose the financial support to oil that Venezuela was supplying them, then they have to make up, as Ricardo was saying, if they can only attract more investment. But if this venue of Title III takes shape, I think it's going to hit hard. However, that has to be put in the context of, I don't call it a trade war, because it doesn't exist yet. It's a trade policy battle. China, U.S., the European Union was not very happy with what the U.S. is doing. You know, certainly firing the shot for the first time after so many years of threatening to do it. But what it means is that there could be repercussions in terms of the reaction from the point of view of the European Union. They're not going to sit, because they understand that now trade tensions, this is the time to take a stand and retaliate or react. So I think that complication, but there is no doubt that the timing of this clause, if it were to be put in effect, now would be a time that would exact more pain on Cuba than at any time probably in the last 15 years.
Can I add something? So because we've gone, I think, into sort of the geopolitical stakes of why this issue has come up now, and I think that's really important to keep in mind. Just one thing, going back to the historical context briefly, when we think about sort of the purpose of not just Helms-Burton, but Title III in particular, there are obviously very complicated, meddlesome property claims issues that need to be worked out that have been on the books since the 60s. But I'm struck by a quote by one of the sort of co-drafters of Helms-Burton, not someone working in the legislative branch, but an activist here locally who participated in that informal way that laws sometimes get drafted in the drafting of this legislation, and who represents a number of claims holders themselves. He was quoted in an Economist piece from 1986 as saying, "We're not doing this with regard to Title III to win lawsuits. The main objective is to drive foreigners out of Cuba." Period. So, in my estimation, the priority with the creation of Title III was never really about finding a necessarily efficacious or quick resolution to these property claims issues. It seems to me that those who created this really saw this as a way to, I think, as was just put, to sort of hit Cuba when it was still down. And I think I'm always struck when we talk about sanctions about who gets hit. Right? There's a lot of parallels between sort of the broader context in which this legislation was initially created and now. In the early to mid-90s, Cuba was reeling from the loss of Soviet subsidies and Eastern Bloc trade. Now Cuba has just lost sort of another big trade partner and supporter, seems on the verge perhaps of losing that support. There was a rise, as I mentioned, of Cuban American political influence at the time. There seems to be another sort of peak in that influence currently with some of the important appointments in the White House. And yet I'm struck by the way in which there was a sense then that now is the time, that if we strike now, the domino will fall. And I always come back to August 1994, the rafter crisis. Cubans out in the streets in Havana, if it didn't happen then, why now? I think sometimes we ignore the more complex and less rosy legacies that recent history leaves us. And so I myself am skeptical of the sort of the logic that, well, implementing this now will somehow have a different result. And I fear that those who get caught in the middle are average people who will feel the impact of increased sanctions, I think, more than anyone else. I think that's the record over time. That's just my thought.
It's an interesting point. I think geopolitically, you have to take the world, when you're looking at rule of law issues, particularly in a global economy, you can never look at them as in a vacuum. Right? You look at the law, you look at the text of the law, and courts have to apply the law, right? But ultimately, you have to also appreciate what is going on in a geopolitical standpoint, and it is a different time. I mean, we have certainly China with the Belt and Road Initiative, investing heavily in Latin America, right? And Cuba is also an important piece of that puzzle, particularly in telecommunications, by the way in which there's an exemption under Title III for telecommunications, right? If you're providing telecommunication services, you're not trafficking, right? And that's within the law. So, Huawei comes to mind because there's been a lot of issues with Huawei recently, and in fact, I can't comment too much because my firm is actually representing Huawei in a lawsuit against the United States, but it's certainly an interesting time. But I think that geopolitically, the Helms-Burton law itself specifically names in its findings Fidel Castro. It specifically calls him out by name, which is kind of interesting. And that's what missing part in the equation, because Fidel Castro's not around, right? And the question is that in itself a sufficient vacuum in leadership? You have an iconic figure for many in the Cuban Revolution, who's no longer around. Obviously, Cuba's continued since his demise and since his death, but in itself, geopolitically, that is an important play, and obviously irrelevant to how Title III is held up in courts, but relevant to the geopolitical dynamic of what's going on in Cuba. Is there a potential vacuum in leadership? Is that also being now coupled with the situation that's going on in Venezuela right now? How is that all being played out is certainly an interesting topic. Not something that courts are going to be looking at, right? Because courts are just going to be focusing on Title III, but certainly an important perspective to keep in mind.
If I just could clarify, what I'm saying is that there's no time to exact more pain than now, but the problem is trade tensions. If the trade tensions did not exist that we have today, probably the U.S. would have been able to have the Europeans and the others not become too, let's say, retaliate in any substantial way. It is the trade tensions now that have been created because basically those trade tensions are going to continue. China-U.S. is one because China obviously is on the road to claiming the #1 spot, and so that is going to continue. But I think it's because of trade tensions between the U.S. and some of the major blocs, the European Union, China, etc., that will make this move more complicated for the U.S. to really enforce. And also, I would assume that we're also looking at major multinational companies. And so if they're claiming for losses, they have to take into consideration their operations now in other parts of the world that could be very heavily much against their exacting that kind of compensation. So I think that you've got to keep the current trade relation tension globally as a factor in, after all, the courts respond to the environment just like people do. So I mean, they're going to take that into consideration.
Yes, well, just one last brief point on the geopolitical moment. I think obviously this is all happening in shadow of what's happening in Venezuela, and it strikes me that this is perhaps a very curious moment to enact Title III given U.S. policy for Venezuela. I think one of the things that's been, from my point of view, surprising, frankly, about the U.S. approach to Venezuela has been the degree of multilateral support that the Trump administration has been able to get for its policy of recognizing the interim government of one Guaido, including from the Europeans, including from Canada. You drop the Title III sort of situation, which they're not happy about. Does that really serve, what you're trying to do in not too far away? Does that complicate that? It strikes me there's a disconnect in thinking about how one thing may affect the other.
And then maybe briefly we could just, if let's say this afternoon we read in the news that it's not suspended, it's moving forward, what do we think in terms of the types of claims that we could see? I think maybe we touched on this a little, but since there's no case law really in this area, Rick, you've already touched on some of that, and perhaps if you could tell us what might reduce the pool of claimants in terms of, I know there's a large filing fee perhaps, and if there's any thresholds.
Sure. Well, the minimum amount of the claim has to be $50,000 within the statute, and that's exclusive of attorney's fees and costs. So it's got to be a claim at least $50,000. That's number one. The filing fee, it's interesting. There's a special filing fee just for Helms-Burton, and it's not in the statute. You have to look at the court rules, and it's $6,548 is the latest number to file a claim under Helms-Burton. Typical filing fee is $400. Right? For a Helms-Burton claim, it's $6,548. So, those are two immediate issues that come to rise. And then also there's a displacement issue. Are you going to have other causes of action besides Helms-Burton? And the statute says if you're suing under Helms-Burton, you're suing under Title III, right? So if you start suing for other claims, it's not going to be certain. They're probably, you can file, you can allege them, but they'll probably be dismissed, and it's going to be focused on Title III. And then, of course, you're gonna have, which I mentioned to early on, and I just to give you a general overview, there will be defenses raised, under some of those companies are operating, even U.S. companies under OFAC licenses. That could be a defense. There's gonna be standing defenses. Is this really the real claimant? Do they have a certified claim under Title III? If they have a claim under Title III that was certified by the Foreign Claims Service Commission, it's conclusively presumed as valid, okay? Because the Foreign Claims Service Commission, which consists of 3 members that heard ex parte the evidence on the value of the claims, right? When they were first initially filed, there were 8,000 something claims, 5,900 and something were approved, I forgot the exact number. Considered, title, ownership issues. It had to be at least 50% owner, a U.S. national had to be at least 50% owner. They looked at the evidence on damages, and then they made a finding, right, after considering this evidence, that was certified to the Secretary of the Treasury, and eventually they issued an order. And you can go to the Department of Justice website and you can obtain all these certified claims, right? And they tack on an interest of 6%. So there will be maybe some claimants trying to say, well, we acquired these claims, after Helms-Burton, we were not U.S. nationals initially, then we became U.S. nationals, and then they have their own claim, their own bucket of how they proceed under these matters. It could be appointing a special master by the court to determine the value of the claim, and then that special master's report is going to be contested. But if they have a certified claim under the Foreign Claims Service Commission, it's conclusively presumed as valid. They can disprove it by a preponderance of the evidence.
Thank you. And I think this might be one of my last questions, so then we can let you say your final thoughts and we'll move to questions. But we might have mentioned briefly what types of companies or industries are more likely to be affected by this in terms of the industry on one side, and then I think the cruise ships get mentioned every time there's a discussion about this, but there's also potentially, I guess, European companies that might have business here and there. Do you have any thoughts, Jaime or Rick?
I think that in general would be the tourist sector in Cuba has been, I think, more impacted by foreign investment from European, from Canada, and everything that has to do with hospitality. So companies that are, have commercial transactions relating to hotels or travel, I would say, because telecommunications, as Rick said, is excluded from trafficking, that would be a sector also that Cuba has that is not, some of the one that would be hit by Title III claims. So I would say that in general, anything that has to do with tourism, and right now, because this limited application of Title III regarding potential defendants that are in these restricted entities, most of those restricted entities are hotels that have to do with hospitality business. So right now, that is already, I would say, the potential area. And I think that if Title III is no longer suspended, by the way, I don't think that would happen today. I don't know what's happening today, but I would be very surprised that it's, completely, allowed to go into effect. I think that would be, again, a limited, application for these companies, maybe certain, non-U.S. defendants from certain countries, but I don't think that. Well, let's say that happened. I think that still that would be the most impacted area.
I think there will be other areas, energy, natural resources, agriculture. These are areas where there have been clearly, as Amy says, tourism stands out, but there are other areas. Let's not forget, of course, that the foreign investment regime of Cuba is extremely complex and doesn't invite investment. And let's also remember that when Cuba would restructure their debt with the Paris Club, all the discounts went into that equity swap opportunity of the credit governments, which was what actually ignited a lot of European investors into Cuba originally. So nowadays, I think that is gonna be a lot of cash up front, and just, you've got to look at the potential here. And I think the foreign investment law, no matter what they say, we don't know who's investing, obviously, because that demonstrates that they don't wanna release that information, because obviously, then they would be giving the US a list of who to go after. So I think that we have to also consider the ability to hide identities in this whole process of Title III as well, because it's gonna be, I think it's gonna be a long road, and that's where I think there is gonna be some hesitation on the part of investment. And Cuba today is not what it was 20 years ago, simply because pretty soon there will be no name Castro. Maybe there'll be a Castro in the government, but no relation to the ones that we're interested to. And so there's a younger generation in the military that, you know, would be willing to consider. But this Title III, I think, will affect those basic industries. Cuba doesn't really have an industrial base of any sort. And that's where, of course, the U.S. would eventually be the biggest source of investment and capital to Cuba when it happens.
Well, I'm not making any predictions on the law because I did terrible with my March Madness pool. I picked Duke, and you know what happened. So it'll be interesting to see what happens in the next 8 hours. Ultimately, you have between 75,000 and 200,000 possible claims that is suspected would be filed if ultimately the suspension expires, which is a lot of claims. Federal judges are not going to be very happy on Monday mornings when you go before them. I think we're going to see some. If we do see some movement, we're going to see some interesting claims. The big question is, are U.S. companies, which are the largest, under the Foreign Claims Service Commission, U.S. companies have the largest claims, right? General Electric, the Chevron, there was a Texaco claim that Chevron had. They all have certified claims that are worth a lot of money. And are they going to be pursuing these claims? That'll be an interesting question, because these are global companies with operations across the world. Are they going to be concerned about the European anti-blocking statutes, how they're perceived in the community if they file the claims? It'll be interesting to see how they react. I guess the cruise lines have taken some attention just because they're right here in Miami, but some of them, and some of them are U.S. companies, right? So that'll be an interesting situation as well.
Thank you. I think we can move on to some final thoughts. We can start with Dr. Bustamante. Do you have anything else you want to share?
With respect to predictions about what would happen, I remember in the lead up to the last date of this time, there was some talk about whether they would include a kind of a carve out for, say, just EU and Canada-based companies, for example. But I also wonder if that's not something that one could litigate on grounds of fairness somehow. I'm not sure. So I think that'll be interesting to see. But I think, I've had a couple of occasions to hear attorneys talk about the potential implications of this and implementation and what the actual process of filing claims could look like. And bluntly speaking, it sounds like a mess. It sounds like an extremely complicated endeavor that is likely to tie up many courts and involve the printing of many reams of paper. I guess what I'm trying to say is that I think that's the point. I think for the architects of those who would like to see Title III implemented, I think that's the point, as much as, again, finding any sort of direct or efficacious resolution to claims issues per se. We should not think that this is being considered in a geopolitical vacuum. I think the point is to scare off foreign investment in Cuba. I mean, I think that's the point. And so what I think is interesting there is just the disconnect that still exists between the preferences of the current administration on that issue vis-a-vis the preferences of some of the closest U.S. allies. I don't see any scenario in which the European Union, for example, changes its position, which has gone from the common position to be basically all in on a policy of normalization of building ties, including ties of investment. So I also see it difficult to imagine some of the companies that are really established there already, say from Spain or Canada, pulling out. But I think this does have implications potentially for those who are thinking about getting into the market, and I think that's the point. And I just wonder, like, again, really to what effect. I'm highly skeptical that this alone creates some kind of a leverage to bring about a policy outcome that those in Washington would like to see in terms of internal change in Cuba. And I'm much more confident that in a broad macroeconomic framework in which the economy is facing very rough waters, that average people will feel the effects, as has been the case for the past 20 to 25 years.
Thank you. I don't know where you can discussion. What was it?
Please go ahead.
I just want to make sure that I agree with a lot of what Dr. Bustamante has been saying. I just want to make sure that I understand from a layman's perspective. So Title III is still in effect as of today. It may not be at the end of the day, but it is in effect today. Am I correct in that?
Well, yeah. Well,
It's a major application of it anyhow.
Title III, what's in effect today is that Cuba restricted list that I may alluded to is basically a target. Title III, technically suing the rest of the world, right, is technically suspended until April 17th.
Exactly, which would be decided today. We would know today. Whether
The notice, 15 days.
we
Right,
would know whether
Whether they're going to suspend it again
right,
or
right.
Now, if it is lifted, then after April 17th, kind of interesting that there's an anniversary.
Yes.
But, so if it happens, then presumably some companies may want to sue. And I think more importantly, there's going to be the threat of a suit that I think that may prevent further investment in Cuba. I'm not so sure what the, from a practical, I think you alluded to that, Rick, about whether or not companies will actually commence legal action or not, because they may be afraid of being some countersuits elsewhere in the European Union, or maybe they have some vested interest or whatever already, like Sheraton. They have now the Sheraton 4 Points. They did file a claim 50 years ago, but then they worked it out with the government and it opened up the Sheraton 4 Points and all that. So I don't know. They may not decide to pursue anything. Let me clarify something. In order for anyone to file under Title III, they must have been a U.S. national at the time of the confiscation. No?
No.
There are two buckets, right? There's the U.S. national bucket, right, under the Foreign Claims, because to file a claim under the Foreign Claims Service Commission initially, you had to be a U.S. national that was expropriated. Under Helms-Burton, now there's a separate bucket, right? So now you have those that became U.S. nationals after, right?
After what? After
Actually,
the law?
Title III is the only, legal framework that allows Cuban Americans that were Cuban at the time of the confiscation and are now U.S. citizens to bring a claim because.
Or you can bring a claim?
Yes.
But the claim must have been filed previously with the Foreign Claims Service Commission?
No,
It
because you
doesn't have to
couldn't
be a
file.
certifying claim, and the plaintiff has to be a U.S. citizen now, has to have a right to a claim before 1996. I mean, if not, it was not the original owner of the property, has to have, been transferred the claim before 1996, but could be a Cuban national at the time of the confiscation. And that is an opportunity that only Title III provides, because neither under the International Claim Commission or after the two sessions of the International Claim Commission in federal court, the act of state doctrine would prevent a U.S. court, taking a claim from a Cuban national to whom the Cuban government confiscated property in Cuba. That is not. But Title III specifically allows federal court to, take those claims and analyze the claims, regardless of the act of the state
So
government. That would
companies
be
like, company like Bacardi could conceivably, that were not US citizens at
Correct.
the time, could file
This would
with
be the opportunity.
our companies only.
Correct. You can argue that it's easier if you have already that certified claim, because in the statute, it's conclusively presumed correct.
Correct.
All right, so if you have that, that's nice, that makes it easier. If not, you still have to, get a special master, or you have to prove the value of that claim, right?
And this is one of the provisions that critics of the law would signal as perhaps the most extraterritorial or novel, to put a better spin on it, in the law. The fact that it recognizes, it gives standing to those who were not U.S. citizens at the time that the action concerned is was put
And
into
the
effect.
plaintiff would always have to be the person that was affected by the loss of the property from Cuba. What happens if that person is no longer alive, an individual, do the heirs have the right
Yes.
to
Yes.
file?
Heirs or whoever, let's say, bought a claim at some point in time,
Yeah, because claims have swapped hands every time.
Right,
There's
right,
there's a market for them.
Right, If you had a right to bring a claim under the International Claims Settlement Act and you did not bring the claim,
then you cannot.
then you cannot, okay? So that's another important point, right? So if you had that right you were a US citizen, the property was expropriated, and you did not file a claim under the International Claims Settlement Act, you got a problem, right?
Or if you did file a claim under the international claim and you lost.
Right.
And you what?
And you lost.
And you
then-
lost,
Then you cannot again find the same claim on the
Under
Title
Title
III.
III.
right. Yeah, the law is pretty extensive. I mean, there's a lot of
Yeah.
provisions to it, right? And it's, you read it, it's multiple pages. It's 4 titles, Title I, Title II, Title III is the one that deals with lawsuits, but it has different sections, and there's a lot of provisions in there, right? I mean, look, at the end of the day, Dr. Bustamante is correct in saying this is messy, Usually, I worked in global disputes at my firm, that's my department, so when you're dealing with litigation involving issues in foreign countries, right, it is messy, typically. Now, it could be even a bit more messy, some would argue, because you don't have a treaty that's specifically governing the relationship between the two countries, right? It's a title, it's a law here, issued in the United States, right, that's governing extraterritorial legislation, right, and that's governing extraterritorial conduct, so it becomes complicated from a legal standpoint, right, it is complicated, but it's still an interesting rule of law issue, right, I know, as some would say, and some have been quoted as saying that Title III was basically enacted to change regime in Cuba. And you read a lot of the statute, and that can be read into the statute, right? It's there to a certain extent. But it's also a rule of law issue, right? Because at the end of the day, there was, under international law, recognizes, convergence of principles of international law recognize that if your property's taken, you're entitled to compensation, right? Expedient compensation is the norm, right? And you have treaties typically that govern this. Here you do have expropriation, right? And Title III calls it confiscation. And there was no compensation, right? And there's a debate, well, some will say Cuba tried to compensate, the US did not agree, but at bottom line, there hasn't been compensation. So there's a rule of law issue as well, right? And how that plays out under Title III is one way it could be played out, and the courts are gonna have to look at Title III and apply Title III according to its wording and according to jurisprudence in the United States. And there is no jurisprudence addressing Title III, so it'll be complicated, but interesting, no doubt.
It's interesting for those of us in international banking and market will know that for sure.
Yes.
The whole issue of extraterritoriality has never stopped the U.S. government from impacting other countries. We have to comply with
Sure.
all of the OFAC and everything else coming out of Washington, whether they like it or not.
Sure.
So I suspect this will be the case here too. What's interesting is those people operating with these properties under an OFAC license, I don't know how that's
That's right.
going to be.
I I think there, the issue seems to be the carve-outs that are in Title III with pertaining to legal travel, in particular. I mean, if we're talking about the airport and the airlines, we're talking about cruise ships, I would think, and I'm not a lawyer, but having read the statute, that, there would seem to be a carve-out that justifies that, right? If you're using property, I mean, airlines are not even the owners of the airport, they're using the airport, to use that example, or the ports for their cruise ships. If they're using that incident to travel that is legal under US regulations, that would seem to be covered, but, you know, I imagine like everything else, this is
But
gonna be litigated.
Yeah, it's gonna be litigated, and whether it's necessary.
Necessary or not.
The word used in the statute is necessary, right? So because it's not, if it would be incidental, right,
It
so it
both
would
has
be,
to be incidental to travel
and
and necessary to
necessary.
complete
So
the
what
travel.
qualifies as necessary to
Oh,
legal
yeah,
travel,
we have
as
to
long as
wait.
there's like a
For
beach
the
where I can
courts.
land like
right,
a
right,
little
so
boat
so
on my
interesting,
own?
interesting, let's look at the cruises, right? If they're parking in other, when they go to other countries and are not parking in the port and are just transporting people by ferry, is it necessary? Is the use of the port necessary? That's interesting. How will the courts interpret this, right? So there is gonna be a lot of words count, right? The words count, and words count for ports. That's a very important view. I mean, a lot of people would say, well, you know, I mean, conservative judges or liberal judges, it's really how judges are interpreting words, right? And how they are interpreting context and what their judicial philosophy is, right? And not to get esoteric, but how they interpret these words is gonna be very important.
I think when you look at it from the point of view of the investor, I think the main impact, again, is gonna be that it's going to discourage investors from making investment in Cuba, because they don't know, there's this legal issue that here, they don't know how it's going to be defined, but just the fact that they could be liable, it's like the banks. They don't wanna take any chance to engage in any type of activity that, you know, they could be slapped with a huge monetary liability. So I think that is one direct impact that is gonna be immediate. It's going to deter investment because they're dealing with an uncertainty here, that they don't know what to decide. Now, when you look at the big companies, that would be the headline companies that would sue under this, we go back to General Electric, as Rick was saying, well, maybe they need the money, obviously, with the problems they're having. So maybe that would be an issue. But when you look at the energy sector, they don't want to, you know, basically prejudice their investments in the European Union area. I mean, they have huge, and there's a lot of government relations at that level of multinational oil industry that they have to be thinking, what are we trading off here to go for something like this? Well, at the end of the day, it also depends on what is the harm of getting this compensation to the global business, and so that's what companies are gonna think. That's why I think the most important impact is gonna be the investor concerns about the risk of being sued that is gonna deter.
It's the
Because right now,
uncertainty that's going to.
yeah, because when you look at who are the investors right now, they are the Spanish, the Mexicans, the Canadians, most likely to be impacted. You have Mexico and Canada. How is the revamped NAFTA agreement are gonna handle that situation? How is this gonna create another rift in the North American Free Trade Agreement when this gets enforced? And Spain, of course, has a big consequence here, and what will the European Union? So again, this is where they were taking that the trading blocs are gonna be fighting over what the stake is in this. But what I'm hearing from the attorneys is that the high degree of uncertainty in the legal implementation of this clause is gonna make many people say, look, what do I gain here, and what could I potentially do?
Yeah, and pointing out, that's an excellent point. You know, to be clear on something and to be complete, the statute also provides for treble damages, and this was not mentioned earlier. So if you have a certified claim, let's just take one of the claims, which I know is $50 million, right? And you multiply that claim by 6% interest over time, compounded, right? To today's value, then you treble that amount, and that is a potential damages award. Significant, right? But if you are a multi-billion-dollar oil company with interests all over Europe, that may be one you don't want to deal with, even if it's that significant, because it's not significant, really, in the grand scheme of things. So, there's going to be certainly a lot of discussions in the boardroom as to whether or not these claims will be filed and what kind of impacts, and a lot of lawyers are going to be working and are already working probably on the assessment of the implications of this. But ultimately, it's a risk-return situation, right? They're going to look at the risk, and they're going to look at the potential return and measure it against all their global operations. And does this make sense or not? That's how many multinationals will look at this, global companies.
There's another possibility that we haven't mentioned, which is they could never actually open the floodgates to Title III, but keep renewing it or keep limiting the waiver to only 30 days. And maybe eventually people figure out the boy cries wolf here, right? But the idea that you've gone from a kind of routine 6-month waiver to suddenly 30 days, that has everybody like, at what point could they pull the trigger? That may be enough to divert some interest. And again, I think that may be in part in the thinking of those who are.
I think that at least have been enough for foreign companies to expand the due diligence that they're doing before, because we have, for example, a couple of clients that for years, this is a hotel chain from Spain, have been asking whether the hotel that they're planning to open in Cuba or managing in Cuba is confiscated property. But now, almost all non-US clients are asking for, a way to find out whether that property is confiscated property. So at some, at some extent, it's already, thinking more about that and making, more due diligence before making a
It's
decision.
also my understanding that OFAC has stopped issuing specific licenses, so I don't know whether this is part of the same process or not, what
Yeah,
your experience is.
long before the Title III revival, I think, is, in fact, for 2 years and being especially
Right.
slow in issuing specific license.
And one way investors can deal, or existing investors in Cuba can settle claims, right? They can settle. You don't have to be sued in court to settle a claim, right? They can settle with the owner of that certified claim, and that person's been made whole. So good luck in suing, right? You have a release from that entity, and that deals with the risk, right? That deals with the risk on both sides.
If I bought a claim, and then the claimant and they get together and settle, so my claim is worthless probably, or what I bought is worthless presumably.
Well, so that's an interesting situation. Depends who has standing to settle, right? If you have the claim, then you have standing to settle, not the other person. If they sold you the claim,
The
Yes.
Cuban
if
government.
they sold you the claims and they settled and they didn't pay you, then you need to see an attorney.
I think we're gonna try.
They could have settled without any money, I suppose.
I know.
Because-
Well,
I'm gonna try to take a few more questions, I'm sorry. We're gonna open it up, I guess you wanna raise your hands, that's good enough. All right, we can start here. Thank you.
Thanks. I mean, like a lot of people in the room, I was around in 1996 when Helms-Burton came down. In fact, I was on one of the lobbying teams. I actually sat in Dan Burton's chair while he was on the floor voting on certain aspects of this bill. And against that backdrop, maybe in 1996 this made a lot of sense, especially given what had happened with the brothers of the Russian flights, which even today is inexcusable. But against that backdrop, we've seen now 20, 30 years of the same tactic of let's double down on Cuba, this is the opportunity. And what's been the result? Nothing. They're very good at that. They're very good at dealing with it. So we take a look at this law, and as President Trump now is free to carve out something for some people, and what do you have? You have 10 or 15 years of litigation on a plethora of issues, from jurisdiction, extraterritorial application of U.S. law, what's the present value of claims, because some of those claimants took tax breaks in 1963 and 64, so their claims are suspect. It's 15 years of litigation. So let's focus on what's in front of us. As Cubans, which I am, and somebody who's involved in the issue, this is a very important issue for us. But I think Mr. Puente analyzed it correctly, that when people sit in a boardroom, this is just a piece of what they do. So let's look at what's in front of us. I mean, we're looking at this as, well, we're gonna crush the Cuban government. The truth of the matter is, you've got Russia, which wasn't mentioned, and China in the hemisphere. China dumped $6 billion into the Bahamas 3 or 4 years ago for political capital. What's to say that given their massive investments in Cuba, they're not gonna say, listen, you know, we Russia, we own PDVSA, you owe us billions of dollars. You know what? We'll forgive some of that, give that oil to Cuba. So we can't put all our eggs in one basket, which is what I'm trying to say. So this bill, you know, this movement on this is very nice and it's very political, but as we get into 2020, into the elections, and this is no longer something that's necessary for Florida, where's this going? Because this has been a failure. It was a great attempt, it didn't work, it was a time to move on. I mean, 11.3 million Cubans who lived there, 8 million were born after what's referred to as the revolution. So this is insanity all over again, which is my point. So we need to look at things rationally, we need to look at what's going on I believe, in Venezuela and in other parts of the world, because this is all part of the same equation. So if the idea is to crush Cuba, I'm not sure it's anything other than wishful thinking. Like everything else, take my opinion with an assault.
Any other,
How do you establish property ownership if you don't have deeds or other documentation on the property rights?
Did we hear that? How do we establish property ownership if we don't have documentation? Do you have any thoughts?
I think that for international trade commission, the claimants were, required to submit proof. And in many cases, if you can see the documentation that was behind the claim, there are actual deeds, property from Cuba. I don't know, I mean, I would say that, the Cuba rate, the property registry in Cuba is not, near to be updated or electronically available. So without a deed, I guess that you would have witnesses and other method of proof that would be different.
Are the property registers open to the public or not?
I think that they are. If you go to the office and you have the opportunity to review, but there are a lot of books with folio numbers and you have to have exactly the information you're looking for. It's not something that is, at least 2 years ago, was not automatically, organized. It's not easy.
I think we have another question right here.
To file a claim would be 50,000 minimum at the time of the confiscation or adjusted for inflation?
50,000 according to the statute, that's the value, what's the minimum value? That's a good
At
question, it's a good
the time
question.
of confiscation?
Yeah,
I would say
I'd say
so.
so, yeah.
Okay.
It's the amount of controversy. It's
Yeah.
not a bad maybe it could be.
Right, well, if you have a certified claim, right, if you have a certified claim, and that's conclusively presumed as valid, that claim, right, if it's $50,000, you're gonna walk into the door. If it's not, you're gonna have to show that it's worth $50,000.
Now, if you have, looking from a finance point of view, okay, you get certified, okay, you're entitled to compensation. Who's gonna pay? Is the Cuban government gonna pay? You, the fact that I take a credit rating, are we gonna take funds from the amount that is confiscated by OFAC since July 8, 1963? Where's the money gonna come from to compensate these people?
Execution is always a challenging question in any dispute, right? And here, ever so more, right? Because then you have to go after an entity that has assets. And if you're gonna go after them in Europe, right? Let's say you get a judgment in federal court, right? $100 million judgment. Is that, the next question is, how do I collect on that judgment, right? First of all, you gotta get that court judgment recognized in a foreign court if that company doesn't have assets in the US. If it has assets in the US, okay, that makes it that much easier. Then you go into an execution phase. But if it's outside the US, that's the key question. Where outside the US? If it's in the EU, you have anti-blocking statutes. You have clawbacks that you're gonna be countersued when you go to enforce that judgment, right? And court judgments, by the way, and not to get off topic, court judgments are difficult to enforce in foreign courts, right? If you have an arbitration award, that's different. If particularly there's a treaty that governs the recognition of that award. But a court judgment, you may have to retry the case again sometimes in certain jurisdictions, right? So collection is a very important question.
I mean,
Let me
do we
ask-
know the
I'm
value,
sorry.
do we know the value of the OFAC, funds that they have frozen over the years? Is OFAC going to?
I saw this cited recently, and I don't have the statistic, but there is, my understanding, there are Cuban assets that were frozen in the early sixties, but it was in the amount of, I think, a couple $100 million, something to that effect. And I saw an interesting discussion as to whether those funds would even be accessible to collect on, and I don't think that's a closed question either. What I saw was that OFAC would have to issue some kind of a license to allow you to collect on those funds. So,
I mean, so the,
That's exactly
I'm
right.
sorry,
There's a
I have to
licensing
cut it
provision.
short.
so the court certification is not,
I think-
not enough.
I'm sorry, I think we'll leave, if you wanna approach the panelists after, but there are some panelists that have time constraint, I'm sorry, it's a very interesting discussion, and I hope it's been helpful, but if we could thank our panelists, give them a round of applause.
Hello? Those who can park in the parking garage in this building, please come see me. I can talk to you.
There you go. That's an important announcement right there. If you have mandatory parking, you need to get a call.
Okay guys, if you park in this building and you have a ticket to be validated, come see me before you leave.
Espero que no se lo
Thank you very much.
pero va a tener que
If you have If you have valet parking and would like to validate your valet parking, please come to the front. Validate. We are validating parking. Please come to the front if you'd like to validate your parking. See? So we're gonna do Found my colleague.
Yeah, that's what we all. So, right, once there was a breakdown
I went to NBC to an investment advisor. We just couldn't reach everybody. This happens. I already got it real weird. Yes, I think so. We got it. Thank you. Yeah, I think so. I gotta go to work. Thank you very much. Gracias, Fernando. Thank you.
Thank you again for coming.
Bye.
Yeah, I was already got up in paradise.
Taking that position, Joe Valley.
They did have to provide to Carlisle to use it. Companies that
Because the wrongful death, you gotta find this
Very good, very good.
They could always wait the reduced.
It's very difficult to teach you. Very difficult to teach you.
We're back in
No, I came in not knowing what I was
What are you doing?
I was just like telling my people about validated parking, and then I was going to make an announcement that we have somebody who might have lost their ticket.
Oh, thank you. Take care.
Your ticket. Your ticket.
I think in many respects it's still.
Adelante.
Bien, ajá, y le dio a otra persona, así que lo que queda.
I think the jury's still out. Cost of financing. See this through.
It seems like it is creating doubt in the market.
que es lo que se llama anti-caution.
Sí, la pintura de Cuba que se
So what kind of, even if they that could stand in just by
El derecho internacional no hay convenios bilaterales.
Pero no, claro, lo que va a no se puede
Es convenio internacional social tiene provisiones de indemnización, porque si típicamente el gobierno expropia esa propiedad, típicamente da una compensación por esa expropiación, dan a los inversionistas
Tres amigos que eran